Center about 4.5 years ago. Before that, I worked at a large national firm doing commercial real estate legal work. And when I got to Empire Justice Center, it was just about the time that the settlement conferences came into play. I have spent approximately 90% of my time representing homeowners on an individual basis in that settlement conference process in my time here, and also doing some of these trainings as well. I do want to encourage people to ask questions throughout. This presentation was really put together with the idea of doing it live and in person as part of our overall 2-day basics training. However, we are going to do it in this webinar format, but I do want to encourage people, if you have questions, please ask them in the question box on your screen. I think it certainly is much more helpful if we get those along the way. And you may hear Becky Case pop in. She is on the line. She will be helping to point out those questions to me if I skip over them along the way. Okay, before we get started, what we're going to cover today is the foreclosure legal process in New York, as well as the settlement conference process. But I want to take a minute before we get going just to talk about, in general, one of the things that comes up often is this idea of who's to blame for the foreclosure crisis that we have been through and continue to go through. And there's a lot of different fingers to be pointed, I think. And I want to go over briefly just some of the things that I hear when I'm out there as far as who kind of people point the finger at. The first is the homeowners. Banks themselves seem to think that the homeowners are, I think, entirely to blame for this, or at least in a large part. That they borrowed too much, that they didn't do, that they, that the homeowners are the ones that caused a lot of this. Certainly, I think people that are working on behalf of the homeowners would disagree with that to a large degree. You've also got the brokers and the appraisers. It was an issue as going back a number of years when people went to refinance. You had appraisers that were willing to tell them the house was worth pretty much whatever the homeowner wanted it to be, oftentimes appraising above what the actual value was, which allowed people to refinance and take out loans larger than they should have. Also, the brokers that were brokering those loans, who essentially, I think, oftentimes were aware that the loans they were putting in might not be the best, but they were looking for their quick commissions. You also have the lenders themselves, who were essentially handing out easy money, and again, not taking a look oftentimes at if the person would qualify or not. I think you have to put Wall Street in there, the issue of how these mortgages were packaged and bundled and sold back off. Certainly encouraged a lot of these banks to take on more risk than they probably should have, knowing that they were not going to be the ones left to hold the bag at the end if it fell apart. Congress is certainly something you hear sometimes, the fact that the different policies that they have come up with, and depending on which side of the aisle you're on, you can find somebody on the other side to blame usually. I think the bank attorneys also are a group that we have to look at, and specifically here in New York State, Stephen Baum. For those of you that don't know, Stephen Baum, who is no longer in business, is an attorney. He was based out of Buffalo, and at his height, he was handling approximately 50% of all foreclosure filings in New York State. As you can imagine, that is a huge number. He was really one of the first foreclosure mills, as we refer to them now. The practices of Stephen Baum's firm got a lot of complaints, a lot of publicity. In the end, his firm is now been disbanded. They lost a lot of their business through some other issues that came up. But I think that was certainly an issue in New York State specifically. You also have the servicers. The servicers of these loans, who oftentimes were incentivized, the way that they were set up is that they get paid by the owners of the loan to service these loans. When it came time to a situation where there was a foreclosure, oftentimes the servicers were getting paid more to foreclose on a property than they would if they figured out a loan modification. So the servicers were incentivized to foreclose. Obviously, that was an issue in the system. It has been addressed to some degree, but it certainly is one that comes up time and again. And then I think the straw that lit all of this, which was the economy. The economy took a tumble back in 2007, 2008. All those other factors, I think, all were bent. There was a lot of bend in a lot of them, and they broke. And what happened was you had an incredible increase in foreclosures around the country, certainly here in New York State as well. From my perspective, when we look at the foreclosure process here at Empire Justice Center, we tend to be very pragmatic. And so while I think there is blame to go around probably to all the parties I talked about, I don't know how much of that we can help fix within the settlement conference process itself. So that's a little bit of background about kind of how we got here, but really what we want to focus on is how does the process work, what can you do to help your clients as best you can. This slide here, I just wanted to give everybody a brief understanding of the foreclosure situation around the state. And what this does, and I'm going to show you here, I'll highlight one field. I'm here in Monroe County. See if I can get this right. Okay, I'm here in Monroe County, which I've highlighted. What this shows you is that this data covers the September 2012 time frame, which was the data at this point that was most recent to get. What this shows is that in Monroe County, 1.3% of all foreclosures are 60 to 89 days delinquent. In addition, 2.5% of those foreclosures are 90-plus days delinquent, and then 3.8% of foreclosures are in foreclosure. We've extrapolated those numbers based on how many foreclosures are in or how many mortgages are in the county. And what you can see here then is total raw numbers. 5,301 active foreclosures in Monroe County. You can, depending on what county you're in, you can see how it plays out for your county. But what you can see here at the bottom is that the total, state totals, 161,129 foreclosures, current active foreclosures in the state of New York is our best estimate at this point. As you can imagine, that big a number, this is still very much a crisis, very much an issue. You hear some talk, I think, across the country that the foreclosure crisis has come and gone from some people. We certainly don't feel that's the case. Here in New York, there are still a lot of homeowners that still need our help and are caught in this thing. I'm not going to go through, I've got a glossary of terms here. I'm not going to go through that. The one thing I will note is that for those that are new to this area of law, one of the hardest things to pick up is all the terminology. Essentially, the foreclosure world has its own language, and there are a lot of terms that get thrown around, and if you're not comfortable, you're not familiar with those terms, this is a glossary that you could look back to. It'll be a lot of things that we'll talk about here, some today, a lot of which in our two-day training, which I'd encourage anyone, again, down in Long Island to attend, we'll go through all of that. The history of the settlement conferences, of kind of how they came to be. Talk a little bit about the previous process. So the previous process was one in which a homeowner that fell into foreclosure oftentimes would try to reach out to their bank to work with them. The process when they tried to work with the bank was very painful, and I'm sure a lot of you have heard story after story after story from homeowners about how hard it is for them to work with their banks. They send in documents, they don't get the bank says they never got them, they send them in, the bank asks for more documents, and that the process takes an awful long time. The way the process used to be was that when a homeowner fell behind in foreclosure, the bank would file the foreclosure in the court system, and it would speed through that court system very quickly. At the same time, the homeowner often would be trying to work with the bank. However, that process took a long time. What was happening was homeowners were losing their house to foreclosure, oftentimes in situations where it would have made financial sense for both the homeowner and the bank to work out some sort of a loan modification. But they couldn't get it done in time because these foreclosures were moving through the courts so quickly. Organizations like Empire Justice Center and a lot of other not-for-profits, specifically down in New York City, I know, were a big push with the New York State Legislature to get the settlement conference language bill passed. And it was passed in August of 2008, became effective in September 2008, and it is CPLR 3408. Originally, this was just for subprime or high-cost loans. However, that was eventually expanded to cover all owner-occupied homes. At the same time that this 3408 was passed, there also was a uniform rule 202.12-A, which puts some of the spells out some of the specifics behind the statute. The statute itself, I want to go through a couple things on here. What the law says is there, the act says, is that essentially the banks are going to be required as part of the foreclosure process. One of the first things in the foreclosure process is to have this settlement conference. The key phrase, I think, in the whole thing is here in Section F, in good faith. That's really the key to this whole thing. What it says is that the parties have to negotiate in good faith to reach a mutually agreeable resolution, including a loan modification if possible. Now, what does good faith mean? That is something that has certainly been, is still an issue. It's something that has come up in a lot of court cases around the state. It's being handled very differently, I think, depending on what area you're in. But that is something that I think going forward we're going to see a lot of arguments back and forth on what exactly good faith means. But it is exactly, that is the key phrase here.
Kevin, can I interrupt with a comment or a question, rather?
Absolutely.
All right, so we have a question that says, many clients we see are 2 to 3+ years delinquent and are not yet in foreclosure. Do you think the current foreclosure numbers are not showing the true number of people heading to foreclosure and that there could be another bubble looming? Kevin, do you mind going back to that chart again?
Absolutely.
Thank you. So it's a bit small, and I think, if you don't mind me jumping in and answering that question. Absolutely. Actually, Empire Justice Center has been working on a couple of studies. We just released one in Long Island where we very specifically addressed that issue. Internally, we call it the ball and the snake, which means that because of all of these problems with whether it's the shadow docket issues or, well, not really the shadow docket, but whether it's the bomb cases that haven't been filed or whether it's the affirmation issues and these cases have not been filed in foreclosure, there are still a great number of people who are, as Diana mentioned, that are delinquent but not yet in foreclosure. And if we had the normal process that we once did a couple of years ago where you fell behind, a couple of months later you would get a foreclosure filing and then we move on through the court process, that has stalled significantly. And so for about 2 years we, in effect, had a moratorium in the state of New York because we couldn't get the affirmations filed in a timely manner so that people could get access to the legal process, which I'm a lawyer, so of course I believe that it's a good thing to have access to the legal system. So yes, the bottom line is that when we're looking at these numbers, this chart that Kevin has up now, we are looking at both 60 to 90 days late, 90-day plus late, and then the number of people in foreclosure. And actually the study in Long Island, and we're working on one in Monroe County, is specifically addressing this ball in the snake, so to speak, where you have a great number of people who are delinquent, who are severely delinquent, but yet not in foreclosure. And so when you have these realty track numbers and these explanations that the foreclosure crisis is over or it's subsiding or it's going away, it's nonsense. We know that that's not true because we have this data from the Department of Financial Services that indicates the exact opposite is true. And in fact, there's a large number of people that are stuck that are now finally, our experience here in Monroe is that we are certainly seeing those people start to work their way through the system and are starting to get into the foreclosure process. So the very brief answer to your question, Diana, is that yes, there is another bubble looming. I think it's starting to work its way through. And on a side note, then Empire Justice is specifically trying to look at that to have conversations with policymakers to identify that that this is still a lurking and a big problem that we need to be addressing and thinking of solutions. Thanks, Kevin.
Thank you, Becky. Okay, on 3408. So the idea behind the settlement conference is we're going to bring together the bank and the homeowner, and we're going to have a conference and hopefully try to get some resolution other than foreclosure. And we're going to do it at the beginning of the foreclosure process. Some of the specifics as far as what we're looking at here, what's going to happen in the settlement conference. The plaintiffs, the banks, must appear in person or by representative who is fully authorized to dispose of the case. That's the language from 3408. In reality, oftentimes that's not the case, and people that are on this call that have been in these conferences are, I'm sure, aware of this. What the banks will do is they'll send their attorney, or if they've hired an attorney that is not local to your area, that attorney will then hire a local attorney where the foreclosure has been filed. Either way, the bank attorneys oftentimes, when they show up at these settlement conferences, will have just gotten an update from the bank that morning, and so they don't have a lot of details about the case. They certainly are not fully authorized to dispose of the case in the fact that they don't have any ability to negotiate. They can't enter the bank into a loan modification. They are essentially there just to give the update as far as where the bank stands. The defendants, the homeowners, ideally they'll have an attorney that's representing them as well. As far as the courts go, it's going to be different depending on which district you're in and even which county you're in. Some of them have a judge hearing these. Some of them have some sort of a mediator or some other court personnel. Oftentimes, I know the law clerks have done them. Some of them are held in court. In open court with everything that goes along with that. Others are just held in a conference room. So that's very much dependent on where you are in the state. The goal, however, no matter where you are, is the same. The idea is to get some sort of a settlement, and either that's a loan modification or a repayment plan, or if the homeowner is looking to keep their house, it's something that's going to allow them to stay in that home. Now, the documents that the bank is supposed to bring, and again, this goes back to the language of 3408, is they have a copy of the mortgage and the note, a reinstatement letter, payment history, and loss mitigation forms. I will tell you from my experience that payment history is something that we rarely, if ever, see an attorney bring to the settlement conference. It's often something that we have to request specifically from them. For the homeowner, I think it's smart to bring anything they have sent in previously before the settlement conference is started. Again, that goes to show the court how much they have already done before they ever showed up, before they've ever gotten to the settlement conference. Any correspondence they've had with the bank, and then the two documents that the bank is almost invariably going to ask for always are the most recent tax return, and also proof of income and expenses. We have some other webinars coming up where we'll go through all of the documentation that's needed. We'll go through that as part of our HAMP webinars. So I'm not going to go into too much detail here, but it is important that the homeowners are able to prove all of their income if they want the bank to look at it in order to get some sort of a modification. The rest of the time today, I want to spend going through the actual path of a foreclosure in New York in the court system. The first stage that we refer to is the homeowner falling behind on their mortgage payments, and oftentimes this is really three reasons that we see oftentimes. One is job loss, cutback in hours, or other cut in their pay. Second thing is medical expenses, disability, or a death in the family. And the third is divorce. It doesn't really matter what the issue is. If the homeowner falls behind on their mortgage, they're obviously going to have the issue of dealing with what's going to happen next. So once they fall behind, what happens in New York now under this 3408 language, 3408 statute, is that what the bank needs to do is send out a notice to the homeowners that says that you have fallen behind on your mortgage. If you don't cure this problem within 90 days, we may file foreclosure. So the bank has to send out a notification that gives the homeowner 90 days to fix whatever the issue is. The authorizing statute is Real Property, RPAPL, Section 1304. The idea behind this, I think, is essentially a cooling off period of sorts. So the bank says, homeowner, you've missed your last 3 payments. You owe us $3,000, and if you don't pay us in the next 3 months, we're going to foreclose. What was happening previously to this 90-day notice was that if the bank felt the homeowner fell behind, they could file the foreclosure right then and there. And as all of you are well aware, the banks can make mistakes. And so what would happen is the bank could, let's say, file a foreclosure against a homeowner that in fact had made all those payments. The payments have been, for some reason, credited to the wrong account. And so the homeowner has, but the bank doesn't realize that. Bank files a foreclosure, and now the homeowner has to not only provide all the proof to make sure that the payments are credited, but is now dealing with having a foreclosure filed against him, all the attorney's fees and court fees that go along with that, because the banks, even if the homeowner was able to prove that the foreclosure was filed wrongfully, the banks were still trying to pass along those charges to the homeowner. And so you oftentimes had situations where it really didn't make sense to have that foreclosure filed. So the idea is, let's give the homeowner 3 months to get this figured out. Either A, they may prove that they actually made the payments, it may be a bank error, or B, they may be able to cure the issue and work with the bank to either come up with a repayment plan or repay it in full at that time before a foreclosure gets filed. If the homeowner pays, that's the end of the delinquency. And so that's the end of the process, and you most likely will never see them as a client. However, let's say that they do not pay their arrears. I'm sorry. I want to give you a brief, this is a sample 90-day notice. So this is the language that I spoke about earlier. The language is all based off of this. It's actually in the statute, the language they have to use, so they should all be exactly the same or incredibly similar. What it's going to say is you are blank amount of days behind and you have to make a payment. You are this amount of dollars behind. The other thing that is required under this is that they have to give notification of how you could contact the bank, and that's what this is here, so that if the homeowner does have questions, they can call the homeowner. Has to include how many days in default, the amount of the arrearages, and also they have to give them a list of 5 local housing counseling agencies in which the homeowner could contact if they have issues, if they need work, they need help with. Now, the question comes up sometimes of whether or not, what if there are not 5 housing counseling agencies local to that person? And that's still an open issue. I know in Rochester we had some clients who received notifications and it listed a housing counseling agency down in the Bronx. And that obviously wasn't going to be very helpful for somebody in Rochester. So if there's not 5 agencies in your area, I think it's still an open issue as far as how that would be handled, but they should at least be letting them know all the ones that are there. In addition, when the bank files this, when the bank sends this notice out to the homeowner, they also have to file info with the Department of Financial Services, notices for monitoring, reporting, and analyzation purposes.
Kevin,
I'm sorry?
Sorry, Kevin. We have a question about an experience that Diana is having. I've seen some banks only send a 30-day demand notice and not the 90-day notice. Isn't this a violation?
Yes, it certainly is a violation. It absolutely is. If they have not got a 90-day notice, that is absolutely a violation.
Right. The 30-day notice is required by the contract, the note that the homeowner signs. The 90-day notice is state required, and unless you have less than 5 loans that you service in the state of New York, you are required to adhere to this requirement.
The 90-day notices have to be sent out to all owner-occupied properties. It used to be just high cost and subprime, but that got changed, so it would need to go out to all homeowners. If the homeowner does not solve their delinquency within those 90 days, the bank would send out what's called a demand letter, and I think that's probably what the question was referencing with the 30-day notice. What the demand letter or the acceleration letter says is that there's been a default of the loan, which means the homeowner has triggered a clause in the mortgage that allows the bank to collect the entire amount due. That's the entire amount of the loan. So no longer is the bank saying we just want the payments that you missed. They now are saying because you have fallen behind by a certain amount of days, and it's in the contract, it's typically 60 or 90 days behind. At that point, the bank has the right to try to collect all the money that is owed on the entire loan. I've got a sample demand letter here. The demand letters are written by the banks. There's no statute that says what they have to say specific to this process. But typically what you'll see in there is how far they're behind, how much the loan is needed to make current. So what the bank, even though the bank is saying they could collect the entire amount, what the bank is really looking for is for the homeowner to pay their arrears. If the homeowner pays to get back to current, the bank is going to be happy that their threat worked, and they're not going to file a foreclosure. They're looking essentially just to get back, the homeowner to get back to current. If the homeowner does not, can't make accommodations that make that happen, the next step is the filing of the of the documents with the court. So what the bank is going to do is they're going to file a couple different documents. One is a lis pendens. A lis pendens is essentially it's a notification that gets filed with your local county clerk, and essentially puts a red flag on the title of the property. So if that property was put up for sale, any homeowner that went to the county clerk, or any potential buyer that went to the county clerk, could see that there is an issue with the title of this property, in this case a foreclosure. The other document that gets filed is the summons and complaint. Now, I'm assuming most people on the call are familiar with what those are going to look like. When those get filed, they also have to get served on the homeowner. And the process server typically is the one that's going to serve those on the homeowner. At that point, the foreclosure from the court system is officially started. So oftentimes you'll have homeowners before this. So they'll be back in this demand letter time frame, or the 90-day notice. And I'll have clients come in and say, I'm in foreclosure. They're not technically in, the bank may even tell them they're in foreclosure. But until you get a lis pendens and a summons, or really the summons and complaint filed here, till that's filed, they're not considered in foreclosure from the court's perspective. Once that summons and complaint is filed, the next thing that has to happen is a RJI, and attorney information, has to be filed by the banks. RJI is request for judicial intervention. Attorney information is specific to this process. Now, before we go any further, I do have a sample summons here. Again, I think most people on the call are probably familiar with this. However, I want to point out a couple things. Up here, the plaintiff filing party. Oftentimes, you'll just see Bank of America or something along those lines, Wells Fargo, City Mortgage, and you'll know that that bank owns the underlying loan. However, sometimes you'll see something like I've circled here on this example, which is as trustee of the American Index Mortgage Loan Trust 2005-AR14, da-da-da-da-da. If you see something like this, what it most likely means is the loan has been sold off, bundled and sold off as a financial instrument on Wall Street. And so that underlying trust that owns the loan is the actual plaintiff party. Again, I just wanted to point that out to people because oftentimes we have questions about what exactly is all that information. And that's what that means.
Kevin, can you go back for a moment about a nuance of the 90-day notice? And we all see this in various ways. The question is, the slide says that the 90-day notice has to be sent to all homeowners, but not if the borrower doesn't occupy home as a principal dwelling. So what about situations such as a married couple with both members on the deed, but only one spouse is on the loan, and then that spouse moves out? So the borrower who's on the mortgage doesn't live in the home, but a homeowner still does.
Becky, you can correct me if you think I'm wrong here. I believe that that notice only has to go to the actual house, so that it would only go to the people that are currently living at the property. It would not go to a spouse that has moved out and moved on to another spot.
Correct. The Well, the primary, my understanding, and I want to reread it to be sure, that the letter is required to go to essentially the person who's on the mortgage, and they're not going to look to see who other homeowners are and where they might live. So they're looking, the bank is looking to the person who's responsible for the mortgage.
Yes. I also see one other question on here regarding if the homeowner, once they've fallen behind and they get a demand letter, if they pay so that they're back to current, does that, the question says, does that invalidate the demand acceleration? Yes. Once they're back to current, it essentially puts them back in a situation where they are, they're back to current. And if they fell behind again, they'd have to get a new 90-day notice, a new demand letter, essentially starts that process fresh. Okay. So the bank has filed the summons and complaint. They've filed a Liz Pendants with the local county clerk. What the next thing they're going to do is file this RJI. And what the RJI does essentially is says, we are ready to move forward on this and have our settlement conference in our foreclosure context. One of the issues that we're running into with this RJI is that, and Becky spoke to this briefly, is that what's happening is homeowners are falling behind. The banks are filing a foreclosure, the summons and complaint with the court, and filing the Liz Pendants with the county clerk. However, they are not filing their RJI immediately thereafter. So what's happening is you have this gap between the summons and complaint getting served on a homeowner and the RJI getting filed, which is going to trigger the settlement conference. So you've got this huge, what's being referred to as the shadow docket of all these cases that are in foreclosure but haven't had the benefits of the settlement conference yet. It is an ongoing issue. I don't think we have time to talk too much about it today, but it's something to be aware of, that you do have a lot of homeowners that are now in foreclosure, according to the courts, but aren't getting any of the benefits of the New York statutes, New York law that is set up for them. So it is certainly something that different agencies are looking at and trying to push New York State Assembly to move on it in a number of different ways. Along with that RJI, the attorneys have to file what's called an attorney affirmation. This was a relatively recent requirement that was made of the banks. Essentially, the bank attorney has to say that they have reviewed the documents and they believe under reasonable inquiry that there are no false statements or facts of law. The attorneys for the banks really pushed back hard on this. There was in fact a real downturn in the number of RJIs and foreclosures that were being filed because the banks were trying to figure out are we allowing ourselves to be opening ourselves up to liability by signing this. We're now at the point where the banks are signing those, and so the cases have picked back up. But so the banks file the RJI and the attorney affirmation at the same time. When they do so, when they do so, that starts the settlement conference process. So what's going to happen is when they file the Liz Pendants, the summons and complaint, and the RJI, the court is now going to schedule a settlement conference. At this point, the homeowners receive the summons and complaint. They do have the option of filing an answer. That is optional. I'm not going to go through right now because we're short on time the pluses and minuses of filing an answer. Regardless of whether the homeowner files an answer, I think the important thing to know is even if they do not file an answer, they do get the protection of the settlement conference, and they will get a settlement conference regardless. So if the answer is filed or not, it's not going to change what happens next. That settlement conference gets scheduled. And now we get into the actual settlement conference itself. The idea behind the settlement conference is trying to get some sort of a deal worked out for homeowners. So if that is successful, if during the settlement conference you're able to get a homeowner is able to get a modification, a repayment plan, something like that, we're on this side now. What's going to happen is the bank will, once they get those documents filed and signed off by the homeowners, filed with whoever they need to be filed with, they are going to then, they have to withdraw the foreclosure from the court system, because now essentially the homeowner is going to be back to a current paying customer. The bank has 180 days from the time of a modification is reached to file that lis pendens saying that the foreclosure is withdrawn, and a stipulation of discontinuance with the court saying the foreclosure, we no longer want this foreclosure on the records. Oftentimes what will happen is if a homeowner gets some sort of modification, what the banks will say is they want to have a 3-month trial plan before they'll make it permanent. In that case, what will happen is the homeowner will make those trial payments. A lot of times the courts will keep the settlement conference open throughout that trial plan, and it's not until you have a permanent modification that the courts then will look for the banks to file that withdrawal of the lis pendens and stipulation of discontinuance. If, however, in the settlement conference, you are not able to reach a satisfactory conclusion, so either the bank reviews the homeowner's documents and they say there is simply no way we can work out, we've looked at the numbers, we've tried to run them every which way, there's no financial way that we can work out a deal with the homeowners. Or the bank makes an offer to a homeowner, but the offer is financially impossible for the homeowner to complete. So the homeowner's payment used to be $1,500, and now the bank wants them to pay $3,000 a month, and the homeowner knows right off the bat, there's no way I can do that, I can't afford it. If either of those situations happen, now it's going to be up to the court to decide, has the bank acted in good faith? Have they met their standard under 3408? If the court feels the bank has met their standard and has acted in good faith, but there's simply no way a deal is going to be worked out, the settlement conference process will end, and that's right where I'm circling here. If that happens, the next thing that's going to happen is if there was an answer filed, you'll have a motion for summary judgment. If no answer was filed, it will go directly to the order of reference stage. Now, if a motion was filed, that will be heard before an order of reference will be granted. Oftentimes in Rochester, where we're located, I can tell you that oftentimes if the homeowner does not have any real legal claims and they put in an answer just to put in an answer, just to have something in, the judges will grant that summary judgment very quickly. If that happens, we have the order of reference granted, or if no answer was filed and we have an order of reference granted, the next thing that's going to happen is a referee is appointed who determines how much is owed. The judgment then is granted, and then the house will be sold at auction. Now, oftentimes I'm asked by homeowners, what's the time frame I'm looking at? How long do I have? A lot of times homeowners get that summons and complaint, and they are scared to death that they're going to lose their house, a week later. Somebody's going to show up at their house to change the locks or leave them a note that says they got to be out in 30 days. What I tell people is typically from the time that the summons and complaint is served on the homeowners, it's typically going to take 2 to 3 months for a settlement conference to be scheduled. Now, again, this is dependent on what area of the state you're in, but I don't think there's any areas that are doing it too much faster than that. And from the time the settlement conference itself will most likely last at least a couple months. And again, if you're down in certain parts of the city like New York City, or certain parts of the state like New York City or Long Island, I know that those can go a lot longer than a couple months. Once the settlement conference process, let's say it ends and it's not successful, from the time the settlement conference ends until the sale of the property, I tell people typically you should expect it 4 to 6 months at the earliest. So putting that all together, what I tell people is 8 to 10 months from the time they receive their summons and complaint. If worst case scenario, they're going to lose their house, that's what I tell them is the quickest it's going to happen. Obviously, it can be longer than that, but we don't often see situations where it's faster than that. I don't tell homeowners that to scare them, but to give them some time frame as far as what they're looking for. We've gone through a bunch of information here in a relatively short amount of time, so I want to make sure if we do have any other questions that we leave some time for there. Any questions at this point from people?
Kevin, there's quite a few questions that I've held out a bit.
Okay.
So the first one is a lot of them are about the 90-day notice and stuff about that. So the one question that you started to ask, there was clarification of the question. So let's say that somebody pays part of the amount that they owe once that 90-day notice is sent. Does that invalidate the 90-day notice, and do they have to resend that if you make partial payments?
No. My understanding would be that the banks, if you, during that, before you've gotten a demand letter, an acceleration letter, you can make a partial payment. However, if you have not caught up in full, the bank is still going to, that 90-day notice would still be valid. What happens oftentimes is after you've received that demand letter, so the demand letter says, homeowner, you are, you're 5 months behind, you owe us $8,000, and we're going to file foreclosure in 30 days, and we're going to go after the whole mortgage. And the homeowner says, well, I don't have $8,000 right now, but I'm going to send them $4,000. Typically, once the banks have sent that demand letter, what they're going to do is they won't accept a partial payment. So oftentimes we have clients come in that are bitterly complaining about the fact that I tried to send the bank a check and they sent it back to me. And that's because part of the language in the foreclosure or the mortgage in the note often will state that once you've fallen behind and a demand letter, acceleration letter has gone out, that clause is kicked in, the bank no longer is required to take a partial payment. They're only going to take a full amount to get the homeowner current. So a partial payment is not going to stop the foreclosure at that point because the bank won't accept it. Now, if it's just that the 90-day notice has gone out but not an acceleration letter, I believe that the bank will, again, they'll take a partial payment. They'll credit your account for the payments that would cover, but I don't believe they'd have to send out a new 90-day notice if you don't get current before the end of that 90 days.
Okay. The next question, again, about the 90-day notice is that 1304 says that the 90-day letter only has to be sent once a year, which is correct. But if it was filed over a year, can you hear me now? I don't know what
yes. Yeah.
Did you hear the question? Let me repeat it again.
Yeah.
1304 says the 90-day letter only has to be sent once a year, but if it was filed over a year before the filing of suit, does the bank have to send another more current one?
I believe they would, but I think that's something that we could check on.
Yeah,
I'm not 100% certain I'm following the question, so
basically they wait. So the 90-day notice is sent,
yep.
And because of all these affirmation issues and all the hiccups that we've endured in New York for the last 2 years, the suit never gets filed.
Understood.
And it's now more than 12 months since.
I believe they would have to resend, but I can't say that with 100% certainty, and I think it's something we can check on, and we can follow up and send I'm not sure how we want to do that, send a email to the whole group or how we can do that, but happy to look on that.
Yeah, I'm still trying to look it up myself right now, but if I come up with an answer between now and 4 minutes from now, I'll let you know. I wanted to address very specifically and clearly, if the property is not occupied by the borrower, which was a previous question, the 90-day notice does not have to be sent.
Yes, I'm sorry. For properties that are not owner-occupied, really very little of what we talked about today is going to apply. They don't need to get a 90-day notice, and they're not going to get a settlement conference either. So if this is an investment property, a lot of these protections are not going to be there for that owner. These were really put in for owner-occupied homes specifically.
Right. So that spouse that we were talking about before that moved out, essentially the spouse that's living in the home is effectively screwed. So, okay, the next question, let's see. A couple of procedural questions. People have asked that the documents be sent directly to them so they can see them because quite a bit of them are in fine, small print. So
absolutely. I'll send out we'll send out an email with all the actual documents that are embedded in this, just as attachments.
Okay. And then we've got a number of other questions here. Some of them are not directly related to what we've been talking about, but let's see.
Okay.
Let's see. Could Kevin talk about the procedure for bad faith motions in the conference process? What I can say is that we have another webinar coming up where we'll be specifically specifically talking about quote-unquote bad faith motions or lack of good faith motions. That's coming up later in the summer. I can get you that date in a moment. But Kevin, do you want to just briefly?
Yeah, I mean, I'll briefly touch on it, but Becky, what Becky stated is correct. We're going to have an entire webinar about this, and frankly, we could spend I think an entire morning talking about bad faith. But I think the most important thing to note from a practical standpoint when you're in the settlement conferences is documenting everything that happens along the way. I think that a lot of times the proof is where the biggest issue is improving that what you claim the bank has done or has not done. Oftentimes it's very difficult to have that kind of proof. So what we try to do is do a lot of our communications with the bank attorneys via email, so we've got a record built up, essentially building up that record. I certainly encourage people to push the envelope on, push the bad faith arguments, because I think it's very early on, and a lot of the judges look at it from they have a lot of different perspectives on what is and what is not bad faith. Becky, do you want to add on that?
No, all I'm going to say is that it's November 20th, and Jay and Wald will be talking about it at length. Or come to the Island training and you can hear it more.
That's right. I was going to say we will be spending, we'll have an hour-long presentation, hour and a half long presentation at our next training in Long Island, the early June, which we'll be talking about specifically about that.
Right. Okay, we've got them coming in now. So let's see. The next question is, what other options do homeowners have after the settlement conference process ends and no retention resolution was reached?
Yeah, couple different things a homeowner can do. First off, I think it's important to note that even if the settlement conference process ends, from the time the settlement conference process ends until the sale date, the homeowner can work with their bank right up until the date of the sale. So if the homeowner has some sort of a change in their financial circumstances, they were looking for a job during settlement conference, the court saw they had no income, the court allowed the bank to move forward with the foreclosure, but now the homeowner has found a job. While you don't have the protections of the settlement conference and the court overseeing the process, the bank, the homeowner can still submit documents, and the bank is required to take a look at them right up until the sale date. So I always encourage homeowners that if they are really, what they want to do is keep that house, and the settlement conference didn't work to get them a resolution, is not to give up at that point, because they are going to have a number of months, and if something changes, they can get re-reviewed. If it's not going to be possible to keep the house, there's a couple different options. One, they can sell the house as a traditional sale, and they can do that at any time. Even when the house is in foreclosure, they could sell the property. They also can do a short sale. So if the homeowner owes more to the bank than the property is worth, the example I use is a property that's worth $75,000. The bank is owed $100,000. You would do what's called a short sale. A short sale is where you'd get an offer. You put it on listed on the market, and you get an offer for $75,000 in my example. You need to go to the bank at that point because they're going to get paid less than they are owed, and you need the bank to give their blessing, essentially, that they'll accept an offer for less than what is owed. Oftentimes, as part of the short sale process, I shouldn't say oftentimes, but some of the time, you can negotiate with the bank so that part of that is the bank saying, in my example, we'll take $75,000, and we also, at the same time, we won't come after you, homeowner, for the other $25,000. In New York, the banks do have the right to recover that remaining amount. That's called the deficiency judgment. They have 12 months to file that deficiency judgment. As a practical matter, oftentimes here in upstate New York, we don't see the banks going after homeowners for the deficiency judgment, but it is the bank's right by law. The other thing, if a short sale doesn't work, let's say you put that house on the market, you haven't gotten any offers at all, you could then approach the bank about what's called a deed in lieu of foreclosure. A deed in lieu of foreclosure is where you're telling the bank, I'm going to give you the mortgage and the title of this property. I'm going to give you the title of this property. You take it, and I'm going to walk away. And let's just call the whole thing off. Let's essentially let's save everybody some time and just take the house back, take the deed to the house, and we're going to walk away. And again, oftentimes at that point, you can get the bank to agree that they're not going to come after that additional amount. The last option, I think, is for the homeowner, frankly, to ride that foreclosure out as long as possible. The idea being that they don't have to make a mortgage payment, they don't have to make a rent payment, they might be able to set aside some money for whatever their next step is going to be.
Okay. The next question I'll address, have any of the courts in New York State found any banks not acting in good faith during conference, specifically when the banks do not render decisions timely and continuously require borrowers to redate their docs? The first response is Jay Inwald covers that extensively in his in his materials. So in Long Island, he'll cover it, and again in November, which is quite a ways away, he will cover it through a webinar format. I can tell you that there are a lot of cases that are address that question in various ways. My best suggestion is probably to go to Pro Bono Net. Those of us in upstate I think are not as familiar with it. Those of you in New York City have been using it extensively for quite some time. Pro Bono Net is it's a phenomenal access point for those of us in this area to look for foreclosure-specific cases and pleadings and training opportunities as well. So look through there. Jay Inwald's materials are quite extensive in that area. In addition, I can say broadly that across the state, people are getting bad faith or lack of good faith motions granted. Interest is getting told, or orders to be told. Bank representatives are being forced to come and appear at these settlement conferences. There are ways to address that with the courts, and they are, I wouldn't say regularly being granted, but they are certainly being addressed in various places with a great degree of regularity in certain courts across the state. So let's see, there's a couple more.
Yep, I see a question here regarding does the homeowner have a right to a settlement conference if the lender is a private individual rather than a bank? The answer to that is no. The settlement conferences are required, as well as the 90-day notice, are required of lenders, and lenders are defined as someone that makes 5 or more loans in the past year. So if you have a private individual that is made the loan, if they're somebody that does that a bunch and they've got multiple loans out there, they may be in fact a lender as far as the statute goes, and they would have to have a settlement conference. It depends on that private lender.
Real quick, there was a question asking about Jay Inwald's materials. If you attended the Syracuse training, it was in that packet. They will be in the Long Island packet. There will be the webinar in November that you'll access those materials. I can also check with Jay to confirm whether or not it's okay to just send it along. But generally, he may even have them already online at the Pro Bono.net website. If you would like them, please send me an email directly, and I will just confirm with Jay that he's comfortable with me sending them out individually to folks. My email address is rcase@empirejustice.org. And I think there's one more question. I think, maybe two now. When a borrower is denied a modification and the summons and complaint was previously answered, what is the implication for the borrower? Does the court allow further negotiation between borrower and the lender?
Well, I mean, I think if you filed an answer, what it's going to do is it's going to after that settlement conference is over, you are going to get your day in court, so to speak. If the legal claims that you have against the bank are sufficient that the bank is a little bit rattled by them and thinks they might lose, then I think that certainly that could be a card to help you in your negotiations with the bank. I don't think the court doesn't have any specific procedure other than settlement conference to encourage negotiation between the parties. However, there certainly would be time at that point to work with the bank directly, but I don't think you're going to have the court overseeing that process at all in any formal way. Anything you want to add to that, Becky?
No, and I apologize. I was half listening, so I was looking to answer the next question. No.
Okay, the final question, I think we got to wrap up here because it's just about 1 o'clock, is what the definition of lender, where that is. And Becky, do you happen to remember? Because I had this question last time and I wrote it down.
I'm looking it up as we speak in one of my old cases, actually. And it's...
Banking law?
I'm looking. Hold on.
Okay, while Kevin and Becky are looking up the definition, I'll take a minute to announce the CLE code. It's going to be Z as in zebra, 48, E as in Edward. I also listed that in the chat feature in case you didn't get that.
Becky, is it 6L, the banking code?
No, well, it references it. It references where to look for the definition of lender in 6L. I'm trying to find the original source of it. And it also mentions it in, I think, 1304. But again, it references you to a different location. And I'm so sorry because I can't think of that citation. But I am.
Tell you what, why don't we can include that when we send out the individual documents that we're going to send out that were included in the materials. We'll also include a, we'll find that site and we'll send that out as well.
Okay. Yeah, good idea. All right.
Okay.
Thank you very much, everybody. I appreciate your time.
Thanks, everyone.